Hi, Bill Henshaw here again, another one of my YouTube videos on current events. This one literally just happened. The 9-0 Parts, aka the U.S. Supreme Court, just announced a decision Monday in LIU versus Securities and Exchange Commission. On the surface, doesn't look like a particularly big deal, but for me and my friend Adam, it is, and it will be for you too, because they've effectively decided a case in our favor. And what's going to happen is they're going to send the case back down, Adams' case, to the Ninth Circuit, and they're either going to take care of business or they'll send it back to the district court and tell them to quietly dismiss the case with prejudice. That happens, $1 million judgment against him will disappear like a fart in the wind and be done with it. It should never have happened to start with. And we were really confused about this initially with this case because both Adam and I know what the hell goes on there. And he sent this unopposed case in there at the end of the last term, and they gave it a number, took it, accepted it, and nothing happened. But my friend got a call from the office of the California Attorney General, not Becerra, but the office, because they're tentatively involved because there were some challenges to the constitutionality of what happened to him with this nonsense. But they said that they got advised by the court not to take any action on the case or submit briefs. And apparently the attorneys for the bastards that got the judgment got the same message. And what we thought was, me personally, that this was going to be a 2-paragraph per curiam decision by the court, reversing the judgment on technical grounds rather than addressing the considerable merits of what went on there. And that's how the old 9-0 Parts work, because the first law course I ever had, the first paper in the first class, Ashwander v. Tennessee Valley. It's the Ashwander Doctrine, 297 U.S. 288, page 341. 7 rules of what they'll hear and what they won't. What do they say in there? Word for word, the court will not rule on an issue of constitutional law, though properly presented by the record, if there is some other ground upon which the case, and parenthetically our rights and the Constitution, can be disposed of. Now, given that, we thought a per curiam, they could, ease the pain, get rid of the judgment, which is the main thing, no harm, no foul, but not make any rulings on the constitutional issues that we not only want to get ruled on, we have a right to get them ruled on. And this court knows that too, and they've said it in their own words, Chief Justice John Marshall. To get information like that, by the way, in my materials, send me an email, uwinnincourt@gmail.com. Constitutional defense document packets and my new COVID packet. You're going to love all of it. So that said, we were very disappointed. First Monday in October, the case got dismissed without an opinion. But we didn't know that this Liu case was there at the time with basically the same issues. And the court could have added Adams' case to it. They chose not to do it, and we know why, because if they did that, they'd be in a very embarrassing position of ruling on one case and not addressing the merits of the other with the person who has status and standing to do it and has made some real issues, not emanating from the 14th War Amendment. So that was the problem. But at the same time, the way they made this ruling is going to effectively win the case from my friend Adam, because the case is going to get dismissed. Exactly the same thing happened to him as happened here. So it hasn't happened yet. I'll keep you updated on this when we get official word, but it may take a little while unless the Ninth Circuit acts on its own, which I doubt they will do. They'll send it back to the district court. Nobody will be officially the wiser that this ever happened. A lot like my South Carolina case, where I wrote an 18-page hand-printed writ of habeas corpus, Article 1, Section 9, Clause 2, non-statutory federal writ, 18 pages, 35 case decisions, no errors. They never officially received this one. 4 years later, I found no evidence of that. And here I am sitting here today talking to you, not wasting away in some South Carolina prison cell because they got a phone call down there. Get him the hell out of there. We can't answer these questions on the record, even though they know they have the sworn duty to do it, according to Chief Justice John Marshall, that infallible icon of Harvard and Yale, who was never wrong, was he? You'll find out more about that by getting my material. Send me an email, youwinincourt@gmail.com. And I'll tell you all about this business with the U.S. Supreme Court and a lot more besides that. And note here, we have an unprecedented window to get some things done, but with all this COVID crap ongoing at the same time. And now with the threat, to people for the first perceived time of maybe losing their jobs, their homes, and threats to their children with this compulsory COVID vaccination that Trump has mobilized federal military troops apparently to go door to door and knock on your door, needles and maybe bazookas at the ready to give your kids a vaccination that you don't have any idea what the hell is in it, what it's supposed to do. And this from a government who has zero credibility, particularly in this area. We don't know. Bottom line question is, whose kid is it and why? We think there are children. That's naturally what you would think. The government thinks, 14th Amendment, all persons born in the United States and subject to the jurisdiction thereof are citizens, and are the citizens of the United States. And therefore, the Fed owns you, they own your kids, and they have for at least 150 years. And that's why I've been my 15th year as of next week, all in, challenging these bastards to end this nonsense. Get rid of it once and for all, get rid of federal regional martial law, the 14th War Amendment, get our Constitution and Republic back. I believe that can still be done. This evidence from this decision on Monday is much stronger than it would appear at first blush, trust me. And I've got petitions there myself. I'm going to have more things going to the 9-0 parts, and we'll see what develops along that line as well. So that said, it's exciting times here. And with the window we have, and with a lot of people now interested in federal regional martial law rule, and here I am with 5 decades of preparation to answer questions like that attorneys either won't because they weren't taught in school, or they won't tell you because they have an irreconcilable conflict of interest with the Constitution that they're supposed to support and our rights that are secured by the Constitution. What they really are is unregistered foreign agents, is subject for a different video. But attorneys, I've only known one that would have helped, and if he were still alive, I'd recommend him, Jerome Daley. But most attorneys aren't going to have a clue. They're embarrassingly ignorant. I mean, it's really that bad. In any case, I will get back to you with an update as soon as we hear things. It may take a little while on this story, though. This is June, and who knows whether the whole summer could pass, but we'll be following it closely and awaiting an order dismissing this case, and I will get back to you formally about that. In the meantime, send me an email, youwinincourt@gmail.com. Like the video, subscribe, tell your friends, get the word out. We have the best chance we're ever going to have to beat these bastards and save our lives and our children and the lives of our posterity. There's no greater legacy to leave than that one. Thank you.